Welcome to The Fine Print, the podcast where we explore the law, its impact, and the people who shape it. I'm your host, Riddell, and on today's episode, I'm elated to welcome Mr. Aaron, associate of a top international law firm with a specialization in arbitration across technology, shipping, and commodities disputes. Having extensively worked on numerous high-profile cases, as well as being a founder and CEO of AITHENA, an emerging legal technology firm, Mr. Tan brings a rare and valuable perspective at the intersection of law and innovation. So, to start us off, what drew you into arbitration, and can you explain a little bit about what the different aspects of your work entails?
So international arbitration is basically, think of it as a dispute settlement mechanism that occurs outside of court. So the traditional method is that you will settle your disputes in court. That means it's full view of the public, so on and so forth. But how arbitration works is that you basically go outside of court to an externally appointed tribunal, and they will help decide your dispute. So arbitration is really useful for a lot of parties because that is where it is considered confidential. People on the outside don't get to see what happens in the arbitration. That's very attractive for example, to big corporates, commercial parties, or even those dealing with sensitive data. So that's really where arbitration shines. And it's one of the reasons that I specialize in it, because it's a very fluid, dynamic process. And it's very exciting to be able to work in that field and to deal with these complex cross-border issues. So that's why I chose to specialize in arbitration, and that more or less summarizes what arbitration really is.
That's interesting on how you were drawn to the fluidity as well as the idea of arbitration being private, and that whole idea of arbitration being separate from disputes and litigation in general is quite fascinating. So building on that, what are some of the most common disputes you see in arbitration compared to litigation?
I'll have to share a bit about what kind of work I do. I mainly do a lot of commodities, shipping, general arbitration. So it's not exactly accurate to say that arbitration is separate from the disputes and court work. Often a lot of the disputes are similar to those that go on in court. It's just that it's taken out. One of the things I would say is quite common about arbitration is that you tend to see a lot more big corporate players involved in it. And the reason why is because generally arbitration awards, it means once you have finished the dispute before the tribunal, and once you finish your dispute before the tribunal, they'll issue what's called a final award. And that final award is generally enforceable in basically all countries who have signed up to this international treaty called the New York Convention. So once a country has signed up to the New York Convention, they are obligated under international law to recognize international arbitration awards. So it is fascinating to see a lot of people use arbitration because the idea of enforceability is very appealing. Let's just say that we have a dispute. Let's just say we're located in Malaysia. Where in Malaysia, we had a dispute. You're Malaysian based, I am in Indonesia. We want to use Singapore to govern our dispute. And once it's done, we can take that award, we can go to Singapore and enforce that award in Singapore. It's that international enforceability that makes it very appealing. And it's that international dimension that makes it very interesting for someone like me to work in that field and specialize in.
The idea of arbitration being international as well as the awards is quite complex and honestly quite interesting, as I'm sure most of our listeners may have not heard about this before. Speaking of the kinds of disputes you handle and arbitration and litigation being somewhat connected yet different, are there scenarios where you find arbitration to be more effective than litigation?
Well, that's a great question. And a lot of whether or not it is more effective than litigation really comes down to a question of strategy. It depends what the client wants to achieve in the course of this dispute. Do they want to, in essence, go to court, fight it out in public because there are reputational consequences for that? Or are you trying to go to arbitration and decide to keep things more quiet, to keep things more fluid? So those are big questions that generally have to be dealt with. And in terms of looking at how they interrelate with each other, yes, strategy is a big portion of it, definitely an important role, but it's also important to see how you adjust the playing field. There are benefits to both litigation and arbitration, and really choosing which one to really rely on really comes down to, at the end of the day, what are the client's main objectives and what can you do to achieve those objectives, and which of these methods of dispute resolution best serve that sort of objective that the client has. So these are the sort of broad considerations that one must have when considering to choose litigation or arbitration. Because there are, of course, pros and cons to both. And that's something that all lawyers have to be keenly aware of.
It seems that arbitration and litigation are both very client focused, and the idea of keeping it either confidential or having the consequences of a litigation dispute depend more on the client and the company choosing to do so. So, moving on to a field of expertise of yours, shipping disputes, what makes them different from other commercial disputes?
Well, I wouldn't say shipping disputes are my only specialization. It just happens to be one of the types of work that I work on. But what sets them apart from the other types of disputes is, first and foremost, well, the subject matter. The subject matter of shipping disputes is always very complex and it's very interesting, especially when we consider incidents such as collisions, oil leakages, so on and so forth. And the reason why they're interesting is not only because subject matter is very live, it's very contentious, it's very controversial. A good example is the oil leakage that occurred last year. It's a great example of a high-level contentious case that has occurred for shipping. But another reason why it's so exciting is really because of the sheer variety of parties involved. There are charterers, owners, managers, all these sorts of parties all playing a role, and there's often a governmental aspect because shipping tends to happen either in international waters or in territorial regions or territorial oceans. As a result of that, you have this interplay with so many different agencies, so many different parties, and often all of them have competing goals. The regulation authorities, the government, just wants to get the issue solved. They don't want to have, for example, the oil floating around. But whereas the charterers, the owners, and the managers will be more interested in perhaps what happened to the ship, what happened to the cargo, who's responsible for that. And it's not only even these parties who are involved. A great example is that third parties, such as you and I, when something like this happens in public areas, like ship spillage in the ocean that we use at the beaches and whatnot, it's a question of whether or not we want to then go after them for pollution, tort, so on and so forth. Those are like third-party claims. The dynamism and the complexity of these sorts of shipping disputes is always very evident. It's very interesting. I always watch that interplay. That's something that's very important and I think very appealing, at least in terms of the shipping world.
The variety of stakeholders, as well as the addition of third parties, is quite intricate, and I can assume it might be quite complex. When it comes to shipping specifically, what do you feel are some of the biggest challenges in resolving shipbuilding or cargo disputes?
The biggest issues when resolving these sorts of things are, first and foremost, deciding on a strategy. What does your client want? And I alluded to this earlier. What your client wants is very important to determining a strategy. But going beyond just the client needs, often a lot of the issues that come up involve sometimes what I would describe as novel points of law. A lot of the original key principles in contract law actually arose out of shipping law. That's because shipping is one of the world's oldest professions as well. That actually formed a lot of the foundation for contract. And watching that interplay continue to develop day on day, even this year, for example, I've been involved in some high stakes shipping matters in the UK. So watching how the law develops in that area is a very exciting process. And that novelty of new cases and new principles that comes up with every shipping case is something that keeps me coming back.
The development of laws stemming from shipping law, as well as other laws kind of interplaying together, is quite intricate and fascinating to observe. Shifting focus to commodities and arbitration, how have sanctions and trade wars shifted the landscape of commodity arbitration?
There are two different types here. Well, one is dealing about the state of the commodities market in general, and the other one is the nature of arbitration. So how sanctions around the world have been playing in on this is really looked at from a macro perspective. There's uncertainty injected into the market, and when there's uncertainty injected into the market, there are questions among commodity traders as to whether or not they should proceed with their contracts at this stage, hold out for a better price, which is what we call the futures market, or simply, for lack of a better word, take the loss, right? They've lost out on that benefit and profit, so maybe it's better to breach. So as a result of all these sanctions and tariffs around the world, one of the things that we must bear in mind is that the impact on markets is significant. And when there's a significant impact on markets, there often are significant disputes. And those disputes tend to arise, at least in the commodities world, out of a breach of contract for lack of delivery, non-receipt of delivery. Also equally common, for example, shipments not meeting their designated, for example, quality under the contract. So all of these become increasingly common in a world that's increasingly fractured. As a result of that, there's an increasing need to resolve disputes. Over the past few months, disputes have generally slowed a little bit, and the reason why is because most individuals in the market are generally waiting to see what happens. But as it's clear now, there's no backtracking on the whole tariff situation, the sanctions, so on and so forth. So a lot of people are deciding to breach their contracts because there's no point in waiting anymore, and it's better to take the loss now. So how it relates to arbitration is that a lot of commodities contracts are governed by arbitration. So as a result of these continuing newly decided decisions to breach, the consequence is that people would now be commencing arbitration claims, specifically for the amounts due under those contracts, for the items in the contract, or simply in order to claim damages. All of these work together to create a situation whereby arbitration disputes will probably be kicking off soon, because it's very clear that the situation may or may not change in the future, but it is seeming to lean more towards that it will not. So people are deciding to cut their losses and go for disputes, which would be the arbitration aspect.
The effect of economics on law is quite interesting to observe, as well as how third parties, as well as companies and other firms are being affected, and most importantly, how arbitrators are being affected in this situation, perhaps being called now or later on. On a related note, with a focus on technology, how are AI, blockchain, and other emerging technologies changing the kinds of disputes that you see?
Well, this is a great question. So I think we can break it down into two aspects here. One dealing with AI and one dealing with the blockchain, crypto, so on and so forth. So I'll speak about blockchain and crypto first. Right now and over the past few years, there have been several high-profile instances where crypto exchanges have basically been found to be fraudulent or have been accused of fraudulent behavior. Unfortunately, in a market such as crypto technology or blockchain technology, that's unfortunately an inevitability, at least for some aspects of that market. So that is an increasingly common area of law, and it's just something that will generally be dealt with on a first principles basis. For example, breach of contract, misrepresentation, negligence, so on and so forth. More interestingly is the AI aspect. AI is generally a new technology. I mean, it's very new. It's only started really coming out in the last 2 years. But what makes AI interesting, at least for the legal sector, is that there are two ways to look at it. First, disputes surrounding the use of AI. And second, the use of AI in the legal profession. And I'll deal with these separately. So when we're thinking about how disputes with AI are handled, we must consider various aspects. First, for an example, who invented the AI, who's using the AI, who is the end user of the AI. There are different frameworks for liability in each of these cases. We must consider whether or not, for example, a developer has breached his contract in providing the AI, assuming the AI doesn't live up to the stated requirements in the contract. The consumer might sue for negligence against the company who uses the AI. A great example is the case of Mofa and Air Canada, right? That exact sort of situation happened. Another common issue with AI disputes is really on a more fundamental basis. What happens when the AI is trained using publicly available information? So that leads to a lot of questions over copyright law and general intellectual property. So there are a lot of dimensions to AI disputes, and it's only going to increase as AI is currently increasingly used in workflows around the world. Those are the types of liabilities that we should keep in mind when looking at disputes around AI. Now, AI in the legal profession is slightly different. We will need to consider, for example, especially in the world of arbitration, what happens when parties and the arbitrator themselves are using that AI. And how parties have dealt with this, at least for the world of arbitration, is there tend to be a lot of AI guidelines that are published publicly. Those guidelines are then made public to everybody so that both the parties and the arbitrator are keenly aware of the types of duties that they would have in order to ensure proper AI usage. So that's very important to ensure that the process of arbitration remains undisrupted and that party integrity, party disclosure, and the general fairness of the proceedings are upheld. So if we're looking at it from that perspective, AI in legal work, that's probably one of the leading areas that will need to be continued to be monitored and developed, watching how these various industries are going to adapt that usage while maintaining that core importance for integrity and that core importance for delivering quality work to both clients and your fellow professionals. So that would be how I see the use of AI in the legal profession and what I mentioned earlier about how the disputes over AI. So those are the two aspects I think are important to bear in mind for this situation.
The contrast between, AI being this emerging technology and the difficulties that come with being a lawyer and having so many more responsibilities with the globalization of AI just depicts how our world is kind of ever changing. So, building on that, do you feel that AI could ever serve as a neutral arbitrator in technology disputes?
That's a great question. And I think right now, I would say that the technology is a bit beyond us. It's certainly, like as a concept, would be interesting. But at the end of the day, the way in which AI works is that to have a neutral AI arbitrator, a lot of it comes down to how that neutral AI arbitrator was trained. What sort of data were they trained on? What sort of questions have they been given? Because the way generative AI works today and in the future, agentic AIs and even more advanced AIs are generally trained on their data sets, and the output that they provide varies based on the data set. If we were to go down that route of an AI powered arbitrator or an AI powered neutral third party, there will certainly be challenges to the AI arbitrator based on the data that they use, based on the sorts of output that they give. And that's very different from a human challenge. A human challenge would generally focus on where they've worked, are their relationships with the parties. But if we have to go and challenge AI powered arbitrators, for example, that involves us basically asking the institution or whoever provided it for background on how exactly it trained. That can result in a large amount of confidential data needing to be disclosed. So, do I think it's possible? It is a possibility. Do I think it is ideal? Probably not. At least, certainly not at the current stage in which they are being developed and designed. So, unless those safeguards are dealt with and there's a way to properly ensure a fair set of training data is used to work on the I would imagine it is a bit challenging at this point in time.
Yeah, I'd agree. I feel that AI right now is too much at an infant stage to have it be developed to the point where we can allow it to have access to confidential information. And perhaps maybe the emotional aspect of lawyers may also take into play if AI has to replace lawyers as a whole. So, building on that and building on more of an emotional, environmental aspect, do you feel that the emphasis of environmental regulations will affect arbitration and arbitration as a whole?
Well, that's a great question. And this is very much different from the AI question. It's really more focused on the environment. So, as a general starting point, the always first question is always to ask who are the people who would be suing in support of the environment? And generally, it would be either individuals or non-profits who will be commencing. They could also be on a state-to-state level. Arbitration of such disputes is more challenging, but not impossible. A great example, the investor-state arbitrations, which basically involve investors going after states. Often, sometimes states have halted investment projects because of environmental concerns, which was the case in some of the recent cases, such as Coke Industries, where there was a subtext behind a lot of the decisions. Right now, it is more difficult to commence arbitration for environmental matters because the foundation of arbitration is generally that it is a consent-based dispute resolution mechanism. It means both parties, for example, you and I, must agree to go to arbitration. And as you can imagine, some states or companies are not particularly keen to consent to this sort of dispute resolution. So that does pose a bit of difficulty. But if you're asking as a matter of a subject, like a subject matter, is it possible? It's not, I would say, decidedly in a non-helpful way, it is not impossible. It can certainly be done, subject to the certain rules, but there would be a certain number of preconditions that will need to be satisfied before we can even commence environmental arbitration. It is a new field that's upcoming. It'll be interesting to see where that develops in the years to come. And I definitely think it's a space to watch, especially since an increasing number of climate advocacy groups going out there to commence court actions. Great example is the European Court of Justice, where I think just last year, a couple of non-profits managed to, one of them succeeded in suing, I think, Switzerland for their rights under environmental protection. So we know it can be done in courts. Whether or not it can be done in arbitration is something that we have to watch out for, and we'll just have to see where it goes.
I think, like all fields of law and arbitration, it just keeps developing over time. And environmental regulations, I think, are just skyrocketing high. There's so much going on in the world right now, and I definitely think that environmental regulations will continue to grow and develop. So, to conclude us off, What advice would you give to aspiring lawyers wanting to enter these fields?
Well, I think my advice, and certainly something that I should have thought about when I was entering law school, is first and foremost, think about what you're passionate in terms of either industry or social issues. One of the blessings of being a lawyer is that you get to be at the forefront of dealing with a lot of these issues, either socially, environmentally, commercially, so on and so forth. You are the first line of defense, or you are the first line of attack. And I think that's something that needs to be thought about more by aspiring lawyers. You need to think about why you want to be a lawyer and what you can contribute. And the reason why I say that is not to discourage people from being lawyers. Instead, is to really think about why you're doing this. One of the things that is very common about being a lawyer is that, at least in Singapore, long hours are common. And in fact, it's not even a Singapore thing, it's a global thing. Long hours are common. Yes, you get a decent pay, but there are sacrifices that come with that. And if you are coming in with the mentality that in it for the money, it will be a bit disappointing after a while because the amount of work you're putting in versus the amount of pay that you get might not feel commensurate. So more importantly than that, for aspiring lawyers, it's really important to really decide and figure out for yourself why you want to do this in the first place. Having that sort of inner motivation and inner understanding about what exactly you're here to do, why you're doing it, and why, more importantly, you're pulling those suffering hours will keep you going when the times are tough, and it will guide you in deciding what exactly you should do when faced with difficult situations. What should take priority? And the answer should always be both your integrity and your motivation should be your guiding lights in this profession. So that would be my greatest advice to aspiring lawyers. Focus on why you're doing it, how you're doing it, and more importantly, how you can do it the right way.
That's so true and invaluable advice. Some people might just come into this profession thinking it's about the pay because they've heard that lawyers get a brilliant pay. And I think most importantly, it's just about having the passion, like you said. As for any career, it's just for having that passion that drives you every morning. Well, that brings us to the end of our episode. Thank you so much for your time, Mr. Tan. And to all my listeners, court is now adjourned. Until next time with the fine print.